The question was how many times are we citing each individual homeowner that infringes upon the codes? Well, it's a process, and that process is that we first have to give legal notice, and that notice have a time frame on it. If those violations are corrected within the time that notice allows, then that particular violation disappears. Now, there is a process we call a repeat violator. That first scenario there was what we call a repeat offender. A repeat violator is somebody that have not corrected the violation within the time the notice allowed, and they issued a court citation and appeared in court. We don't have to go back through that notice process anymore if they violate again. We just go straight to citation. An offender, we have to continue to give notice until it reaches the point of a citation. But after 6, 7 infractions, we can solicit the courts to say, well, this is a nuisance. Will you allow us to issue a citation for this nuisance?
And the other thing I think he said was important, if you're in a homeowners association, and I don't know if everyone heard this, he said that if your association is not keeping up with the pool and the landscaping and those things, you can call code enforcement and have them cite the association. So that may be another tactic. Someone had a question earlier about how could they get their association to do something. That's a very important point.
Yes, sir.
His question is, if you violate a covenant that isn't necessarily a code, does the HOA have a remedy other than assessing the homeowner? My experience has been, if a homeowner is violating a covenant, we will continue to assess that homeowner based on our covenants until it's paid. Obviously, if the homeowner is defiant and the homeowner does not want to pay at the time that he or she is assessed, then those fees will remain on the homeowner's book until such time as they attempt to close the house. So at some point, it will be addressed. But, that doesn't necessarily remedy the immediate problem. So if you have a homeowner that absolutely refuses to get their home pressure washed, for example, assessing fines that they're not going to pay anyway does not eliminate the problem. But, I don't know if in certain counties, if having not pressure washing your home, it may be a violation of a code in your county. It's always best to follow up with your county, because you may not think that it's a violation of code, but it just might be. For example, in Cobb County, we are not allowed to park, and this may be other counties as well, we're not allowed to park more than 3 cars in our driveways. A lot of people are not aware of that. So, of course, when I see 4 cars, guess who's calling Cobb County? So it's just those little things that you may not realize. So my recommendation would be to always call first and find out if you can remedy it that way.
The other thing I think that is, in addition to assessments, and may not be very applicable now, but come summertime, that cutting off access to the pool and cutting off access to other amenities is another option that is frequently used by associations, and we get most of our assessments paid come summertime when the pool opens.
Yeah. Her question is, does the court need to have the fining structure on file? And I'm assuming you mean like filed with the clerk's office or something like. And Marvin can probably answer this better than I can as an attorney, but when you have your day in court, obviously you will have a copy of your covenants with you and whatever supporting documents that you need. So I don't think that would be necessary for you to have.
Covenants don't have fines on them, though. It's a general document, so we incorporate it into the rules and regulations of that.
Right. Right. Right.
I don't think that you are required to have them on file with the courthouse. Again, you may or may not have been here earlier. A lot of times what attorneys will do is that when you adopt something like that, they will attach it as an exhibit to a previously filed document. And one of the reasons they do that is so they can just keep up with it. It's like, okay, well, where can we go to find all of this stuff down? But so they do that for that reason. But I don't think it is required, but typically the fining procedure is outlined in the covenants. In your case, it's not outlined in the covenants. I do not think that you are required to have it on file with the court, but certainly I think that before you can enforce it against a homeowner, you've got to show that you've provided some type of notice to that homeowner. Otherwise, I don't know that it will be enforceable. Let's say, for example, you put up a wrought iron fence and there are no wrought iron fences allowed in your subdivision. The HOA can pay somebody to take it down and remove it and charge it to your bill and put a lien on your house for it. And so the pressure washing thing is similar. It goes a little bit further and probably clouds the water a little bit more with pressure washing because, you know, I don't really know how you know if someone's house needs pressure washing that bad, but with the fence, the example is a little clearer.
Yeah, well, in actuality, yours and her question is the same about the pressure washing. That is a code violation. You cannot allow mold and mildew to grow on the side of your house. You have to maintain it. You have to keep it clean and sanitary. So that would be a code violation within itself.
A lot of people don't really realize what they're signing on to. You got to really take these things serious and read those documents when you're signing on. The association has the right to enter your premises to make sure that you are complying with the covenants. I had one case where a lady put in a basketball goal in her backyard, and they said, nope, you got to remove it. Now, this was a concrete, court that was long, and she had to remove it, and she refused to remove it, so they went in and removed it for her and charged it back to her association. Absolutely not. A homeowner cannot be evicted. Only a tenant can be evicted. A homeowner can be foreclosed upon. A homeowner cannot be evicted. Only a tenant can be evicted.
His question
Yes.
is, how can you monitor water usage to a unit that has not been paying their HOA dues?
Yeah, and I think he's saying his question was really is if you live in a building and there are no individual meters for each unit in the building, how can the association bill those people? What I've seen in the past is that it's done on a per unit basis, right? And so some people say, well, that's not fair. You know, she's over there washing dishes and washing hair and I don't use any water. But the way that I've seen it done traditionally is based upon a pro rata share based on each unit. So each unit is divided. But typically I think what you got to do even more is follow up. The association really ought to go back and redo it.
We had a very bad experience with water meters, master meters in a community. Yorktown condominiums, a few years ago, large complex that the people owned condos there. They were paying the HOA their water fees every month. You follow me? Turns out the HOA and management was not paying the city of College Park, where the residents thought that they were paying every month to the city. So ends up they come up with a $250,000 water bill with us over a couple of years. The residents are out of the money. The HOA, the management, left town, left the residents holding the bill. So if you're paying a water bill, check with the municipality or the county to make sure those bills are being paid to your address. And if you can get a receipt from the HOA for every month that you paid a water bill, get it. I cannot stress that enough.
The process of putting a lien on a unit. Most, and I'll let the panel talk about this as well, but most associations automatically have a lien, have a statutory lien for assessment amounts that go unpaid. Now, in order to perfect that lien, you have to file the lien with the clerk of court. But typically, in order to really perfect that lien, you've got to go get a judgment. You've got to go to court and file suit and get a judgment, and then that really makes your lien even that much stronger. But the association has, typically they have statutory liens for the assessment amounts. And I'll let maybe someone else, Monique, may want to address it as well.
Yeah, and what you're saying is absolutely correct. And in the community in which I was the president, we had to pursue some of the homeowners who were delinquent. And one of the things the attorney did, and I guess we'll talk about this in detail in collections, but you file the correspondence, you give them an opportunity to respond, and then if there's no response or whatever the case may be, then you can file the lien and you will also get a judgment. There's a lot of thought as to whether or not judgments should be filed because of the new mortgage laws that passed. And those are such that whenever you close, and this is kind of going off course a little bit, but whenever you close, you have to get a clearance letter from the HOA. So that just really went into effect about a year ago. So the question becomes with a lot of the board members, well, since it's required to get a letter, should we spend money in pursuing a lien and a judgment? And the answer is always yes.
A lot of times we use these terms interchangeably, but they really are not interchangeable. Declarant, developer, and builder, okay? The declarant is the one that is the really person that has the power. The developer or the builder could come or go and change, and the declarant is the person that has the power. Now, if your original declarant went under, there likely was an assignment of declarant rights. And if there's an assignment of those declarant rights, you need to try to find out who the declarant rights were assigned to. And so I guess I say that to you is, if the person that built the fence behind this, if they are the declarant, you might be able to send them a letter saying, hey, this fence is out of order, you have to remove it. The declarant has the right to change the declaration on their own. So the declarant could write, they could say, hey, well, you know what, you're right. We did not have the right to do it, but we're amending the declaration, and now we do have the right to do it.
And just to add a little bit more to that, the original development was a zoning case from the declarant that had conditions attached to it, such as the fence. Well, when the development went under, it was no longer connected to that particular zoning case. So now the landowner, which is the declarant, can sell each lot of land to any individual builder, and that builder have a right to solicit the municipal body to say, I want to build the structure in this manner, including a fence, and it can be approved through zoning. But the existing communities, like Commissioner say, can send a letter and ask, would you please adhere to the previous declarant, so it'll be uniform throughout the community.
And just to be clear, just because it gets approved through zoning, just because you go get a building change or anything approved through zoning with your local county does not mean that it's going to meet approval with your board or with your association. So you want to check with both. People don't necessarily understand the management company works for the board. The board can hire and fire the management company at any time, and people act like the management. I go into associations, even in my association before we took office, the board people were acting like the management company was in charge. And so you have to know your role and make sure you know everyone else's role in the process.
If I might add before we move from this, because what you're talking about is somewhat of a challenge we faced in my community. The majority of our community was already built out, and we had almost a fourth of the lots still remaining to be developed. And we've had a couple of different builders come in looking to do something. One of the things we did, and I was thankful for my previous president, because she really hounded them in trying to make sure they understood what our overall goal was in our community and what we had already agreed upon. And because we're able to put enough pressure to them, reminding them of those things, and more or less saying this is our demand, we don't really have that legal right, but they understood that we would help them sell, or either we would help slow their process. So when they began to understand we could help slow their process, they then capitulated. In two cases, we had builders say, you know what, no, this is not what we wanted to do. And now we have a builder in there that said, okay, we understand what you're working for. We're all working for the same common goal. And now we're getting a result we want. It didn't cost us anything in a court. It didn't cost us anything anywhere as far as legal matters go. It's just constant conversation that came from more than one voice. So maybe that helps you as well.
Squeaky wheel gets the oil. The question was, if someone is not paying their association fees, but they have a renter inside of the unit or the home that is actually paying rent, can the association collect those fees? The short answer is yes, the association can. The association, most declarations reserve the right of the association to assume the rental payments from any renter, okay? Now, I don't know if you can assume the rent because the person's roof is in disrepair. You have to, it would have to be a covenant violation. You would have to have a clear covenant violation. You would have to send notice of that clear covenant violation, follow the procedure and for fining and those things, and then you could be in a position to say, hey, we've done A, B, C, D, E, F, G. Now we have no other option. We're going to assume the rent and we're going to send a letter. We're sending a letter to your tenant and we're copying you and we're telling your tenant that if they don't pay the money to us, that we're going to file for eviction. So the association has the right to evict a tenant. And so if that tenant has paid the landlord and the landlord has not paid the association can evict the tenant.
And
And keep paying. That's right.
You want to make sure that Georgia law says the owner cannot evict that tenant for taking care of HOA.
right, and with that scenario, with the roof being in disrepair, that's a code violation in itself. So you can eliminate the issue with the eyesore by whatever municipality you're in is contacting your code compliance people so that roof can get repaired.
Okay, but we're circling my primary question, which is, does Georgia law stipulate that if in fact the tenant is paying the HOA, that the owner cannot evict them?
Yes, ma'am. They will not be able to evict them because the payment to the association will satisfy their rental payment for the month. I cannot imagine any judge that would evict someone that paid the money, their monthly rental amount to the association instead of the landlord because the landlord is behind on their association fees. The pecking order is state code, state law, the official code of Georgia annotated. Then it's case law, because case law interprets the official code of Georgia annotated. And then it is the Declaration of Protective Covenants. Those covenants run with the land. And then the next is the Articles of Incorporation of the association, and then the bylaws of the association. You're turning off the water to some place where somebody is renting. And then if you turn off that water, that place is now uninhabitable based upon state law, and they've paid rent, then they may be entitled to their money back for the rent that they've paid, and there may be liability on the association as well.
And
The liability is the difference. You can't sue the water company for turning off your water, but you can sue the association if they did it wrong.
Right, and also with that question being asked, if we find a unit that the water company and or the association have turned that water off, we go to Human Services to relocate that family, and that owner is responsible for the upkeep of that family until that water is turned back on.
I didn't know that.
That's the difference.
Ms. Young.
Mic drop.
Yes.
That we enforce state laws, county ordinances, and corporate ordinances now. We use state laws. The county can take that state law and make it more restrictive to the area that we serve, but it cannot water that law down. Ms. Young.
I don't know if there's that is contained in the code. That is typically contained in the Declaration of Protective Covenants. The question was that they are finding more and more renters in their association, and there's a limit. Number one, you're supposed to get permission from the association before you rent, and number two, there's a limit of 10%. And I don't know how many homes you have, but the problem becomes, I don't know that there's much that you can do against the renter. You may be able to fine the landlord for not getting permission on the front side. Now, this rental thing is very important because if you have more than 20% of the homes in your community that are rentals, then your community is no longer a single residence community. It's now become a rental community, and it's a lot harder to obtain loans and for people to purchase. So when you get ready to go sell your home, it's going to be a lot harder to sell. That is one of the reasons why you want to make sure that you stay on your board members. I would submit to you that, you have to put pressure on your board members, because I would submit to you that they have a fiduciary duty to make sure that people are submitting rental applications. I would submit to you that the board members have a fiduciary duty to make sure, as your declaration requires, that no more than 10% of the homes are rented. And if they are renting it, there likely needs to be a fine. I've got a situation now. There are only 44 condos in this place, and they have the same 10% limit. And there are 4 condos that were exempted from the rental. So the 4 people from the beginning are the only ones that can rent, and no one else in the entire condo can rent. What the association is doing now, they originally started out with a $100 a month fine, and they've gone up to a $300 a month fine just recently. So you may want to look at some of those options.
Her question was that if the HOA is not helping the homeowner correct the issues that exist on the property through their regulations. Well, earlier as I spoke, law don't have anything to do with agreement. If there is a code violation that exists, then us as a governing body have to deal with that code violation, regardless of what kind of issues the owner and the HOA have. We have to deal with the code violations. So we can address the code violations where you all carry on that other part of that dispute.
Typically, HOA membership is mandatory, and most of them HOAs, at least the ones that have been created in the last 10 to 20 years, membership is mandatory and required, and so are your fees.